Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the Self-insurers in Australia podcast. I'm Alorna Strong, a partner at Hall & Wilcox, and I lead our national insurance practice. And I'm delighted to be your host for this new season. In this series, we'll be talking about the issues that matter most to self-insurers, things that come up in day-to-day claims management and how you can handle them more effectively. So whether you're listening from the office, out for a walk or on your commute, thanks for joining us. Today, I'm joined by Tim Ainsworth, my esteemed colleague, who is a partner in our statutory insurance team in Sydney. Welcome, Tim.
Thanks, Alorna.
And today we're going to be exploring psychological injuries and looking at really what is compensable, how you investigate psychological injuries, and whether there are any defences available to these claims. So I'm really pleased to have you here, Tim. I might just head into our first scenario and ask you a couple of questions afterwards. So here we go. Simon Taylor has been employed with Smart Utilities for over 18 months. Over the past 6 months, Simon's performance has declined significantly. Key issues have included colleague complaints, customer complaints, Simon missing deadlines, and some poor attendance and frequent late arrivals to work. In response, Smart Utilities put into place an informal and then a formal performance review. Firstly, Simon received an initial verbal warning followed by a written warning when there was no improvement in his conduct. The process has taken some time as Simon has been on and off at work and refusing to attend these meetings. In October 2025, Simon lodged a workers' claim for compensation, alleging bullying and harassment by his direct supervisor and team leader. The claim included allegations for being singled out and micromanaged, as well as being treated unfairly. Attached to the claim was a medical certificate from his GP stating that Mark is suffering from stress due to being bullied and harassed and that he is currently unfit for work. So, Tim, that was a lot to take in, but one thing I just wanted to ask you was, is stress an injury? Are there any thresholds or tests in order to satisfy when lodging a psychological injury claim?
Yeah, I think generally speaking, we would say no, stress is not an injury. Stress and indeed anxiety are things that we experience as normal emotions. In New South Wales, in addition to the definition of injury and disease injury, we have a separate section 11 capital A of our 1987 Act, which deals with psychological injuries, and it adds to that definition of injury that it needs to be a psychological or psychiatric disorder. Stress doesn't quite fit the bill there because we all get stressed. The other thing too is that in the context of a claim for weekly payments, well, an allegation that there's incapacity as a result of an injury, that section 11A specifically provides that a certificate is not acceptable if the diagnosis is stress and doesn't include appropriate medical terminology.
Oh, okay, that's good to know. So in terms of the condition now, so that's probably a basis upon which you might not be wanting to accept the claim. Leaving that though to one side, Tim, what sort of investigations would you start off with if this claim was popped on your desk today?
Sure. And it follows on from that. I think the first thing you need to do is to go back to the general practitioner and make that inquiry. Generally speaking, you'd be asking some questions of the GP, both in relation to diagnosis, but also causation.
Okay.
I'd be interested to see the clinical records too. It's always important to have a look at that medical history to see in what context Simon in this case has gone to go and see his GP and what complaints that he's made. But particularly in the context of psychological injuries, although obviously workers' comp is strict liability subject to the relevant connection to employment, we have a further provision, and it forms part of that section 11A, that precludes psychological injuries if they're wholly or predominantly as a result of particular action. This is also one where I think early on in the piece you'd be wanting to make some inquiries of the employer and beginning to get a factual matrix together.
Yeah, so obviously understanding the psychological basis if there's any history, and then also getting your head around what the facts are of the particular case. Obviously, a lot of these are he said, she said. So putting that factual and medical matrix together to, I suppose, create a picture of what's going on here. You talked about wholly or predominantly, I think, acting reasonably. Do you think in this scenario there are any defences or any such provisions in your legislation that smart utilities may be able to rely on to defend this claim?
Yeah, very much so. The provision is that section 11 capital A, and the first subsection of that provision says that no compensation is payable in relation to a psychological injury. So that is, it's accepted that it would be a psychological injury for all purposes, but not compensable. And then it says if the injury is wholly or predominantly as a result of reasonable action, and then taken with respect to different little categories of actions that might be taken by an employer. So it's different to some of the other states that talk about administrative action more broadly. Mm-hmm. But in this case, what we're looking at here are aspects of a discipline, which has a broad interpretation in New South Wales, and actions with respect to performance appraisal. And there might be more as the factual investigation goes on, but those particular categories of action fall within 11A. And if it were established that the whole or predominant cause of Simon's psychological injury was one of those actions and they were conducted reasonably, then there would be a defence that the employer could rely on.
Okay, so I suppose just to summarise what you've said, so effectively we need to first determine whether or not this injury is psychological, falls under the definition and would be compensable, and stress we think probably wouldn't fall under that category, but leaving that to one side and assuming that stress or there's another psychological diagnosis, once you go back to the general practitioner or you get an IME, for example, to investigate whether or not there is a psychological injury, and assuming there is, then that would provide a basis for the employer to then look at those reasonable or management action or the grounds that you refer to in your legislation to see whether or not they could be defended.
Yeah, that's absolutely right. So the key issues are this idea of wholly or predominantly. So we've seen already that Simon has talked about, as far as he's concerned, there's been micromanagement, he's been treated unfairly, he's been singled out. Now, that might still be conduct that is in relation to those actions, which might mean we're still okay on our wholly or predominantly. But he might raise other things too about not getting a piece of cake at someone's birthday or whatever it might be, to try and take away from that wholly or predominantly idea. And then the other component of it is, once you've put it into one of those categories, is that reasonableness component.
And what sort of evidence, Tim, do you think you'd need in terms of proving those other aspects of that defence? So the reasonably component, for example.
Yeah, that's right. So there's two components. That the wholly or predominantly is a question of medical causation. So in those circumstances, we'd be looking to either the treating doctors or an independent medical examiner to make a comment on the whole or predominant cause from a medical causation point of view. And then there's the reasonable action. Now, both identifying the nature of the action and whether it is reasonable or not would ultimately be legal or quasi-legal questions, and therefore it's factual evidence that's required. So in this jurisdiction, we mainly proceed in the Personal Injury Commission with statements rather than oral evidence. So sometimes in these types of cases, you'll see oral evidence as well, but as a preliminary and in order to look at whether that defence is available, you conduct a factual investigation and get statements from the various managers and get copies of the correspondence and the documents associated both with that informal and then formal performance management that took place, just to get that picture. And as we were discussing earlier, if you've got the clinical records, you can then start to form that chronology between the factual and the medical issues, which will certainly assist, particularly if you're getting an independent psychiatrist to look at this kind of case. If they've got that picture of the onset of symptoms, it's generally speaking, they're in a better position to provide a proper comment on what's the whole or predominant cause of a psychological illness.
Okay. And would you, representing the employer or the self-insurer, would they be putting that decision in writing, or how does that aspect of it work?
Yes, they would. They would. If there's going to be a decision that's declining compensation, then Section 78 of our 1998 Act says that notice has to be given to a worker of the reasons for that decision declining liability. So the notice provision set out what needs to be in that, and so it's a written decision that needs to say what is the legislation that's being relied on, what is the evidence that's being relied on, and all of the evidence, both for and against the decision, needs to go in with that notice, and it needs to provide the reasoning for the decision. That written dispute is then what becomes the dispute in an application to resolve a dispute if it's challenged, that goes before our Personal Injury Commission.
Okay, excellent. Thanks, Tim. That was a great insight into how you deal with a psychological injury claim. Just for our listeners, I think in some other states, a factual investigation is also called a circumstances investigation. So just to clarify that, I think in Victoria we call them circumstances investigations. And IME, obviously, I think I mentioned that word before, which is an independent medical examiner, which Tim referred to. Okay, great. Fabulous. Thanks, Tim. I think I might head on to our next scenario. So let's jump straight into that one. So Monica Bing is a 34-year-old administration officer. She's been with Friends Incorporated nearly 5 years and has consistently received positive performance reviews. Her direct manager, Chandler, has overseen Monica's work for the past 3 months. Monica begins to feel increasingly uncomfortable with Chandler's behaviour, which included compliments on her physical appearance and unwelcomed physical contact, such as placing a hand on her back or shoulder during conversations. Outside of work, text messages late at night, including compliments and questions about her personal life, and unsolicited social media interactions, including liking old photos and sending private messages on Facebook and the like, have made her feel like she's being surveilled. Monica lodges a work cover claim alleging sexual harassment and harassment against her manager, Chandler. She's diagnosed to suffer from an adjustment disorder with mixed anxiety and depression. So, Tim, does it matter in this scenario that a lot of the inappropriate conduct, or what is alleged by Monica against Chandler, occurred outside of work hours?
The short answer is it might, which is perhaps not very helpful for you, but in New South Wales we have an injury can be what is referred to as a personal injury, or an injury can be what is referred to as a disease injury. And there's a lot of ink's been spilled in terms of case law about which is which.
I can imagine.
Briefly, a personal injury means that there's usually something sudden and ascertainable, and there's some Commonwealth High Court decisions on this that I think apply across a number of jurisdictions and be aware. Whereas that disease is more to our understanding of what a disease is. It's often something that comes on gradually, and in New South Wales, employment needs to be the main contributing factor to the contraction of a disease or to the aggravation of a disease. The other thing too is that the other distinction is that a personal injury can arise out of employment or be in the course of employment, but a disease injury has to be either contracted or aggravated in the course of employment. So it does just create a little causal issue, particularly in a case like this where you've got an employment professional relationship that's all tangled up with a personal relationship.
So I suppose if we assumed that nearly all of the conduct was happening outside of work, you'd saying that probably doesn't make a difference in terms of the relationship that Monica and Chandler, because they're one of supervisor and supervisee, or does that matter at all?
The arguments that I'd suggested making are technical arguments, and obviously you can take the human element out of these things, and there's going to be a great deal of sympathy, because part of what would be looked at in that context is that this employment relationship of supervisor and someone who is supervised means that there is certainly the potential for that the nature of that relationship to flow through to the conduct that Chandler in this case thinks he's entitled to be carrying on with. So I think that whilst you would definitely look at those things, because there's always the chance that this has initially arisen in the context of social environment rather than work environment, but obviously the sympathies of any member or judge that's going to be hearing about the facts of this case are going to be with Monica.
Yeah. So do you think, for example, the fact that Chandler and Monica would probably have never had a relationship or Monica would never have experienced, if her allegations do prove true, she would have never experienced these sorts of advances or touching by Chandler had it not been for their employment relationship? So really the behaviour is incidental to the employment connection between the two of them.
Yeah, that's right. And when you look at some of those vicarious liability cases as well, when you're looking at that employment relationship, when you're looking at the conduct of a supervisor, and I think NADU and Channel 9 that we've got in New South Wales, you start to see that if someone is involved in supervising or managing someone, even if they're doing it in a completely inappropriate manner, such as in this case, the employer would still be vicariously liable for, in this case, Chandler's conduct. So that would suggest that the employment relationship has that breadth to cover conduct that falls out, strictly speaking, of the way it should be done, but it is part of the actual doing of it, if I can put it that way.
Yeah, so the actions that take place might take place outside of hours, but the reason for them taking place is that they probably eventuated or originated, rather, is the word I'm looking for, from the employment relationship. So Tim, just going on further from that discussion, if Chandler, say, admits, so if you had arranged a factual investigation, as you refer to it in New South Wales, if you had arranged that and the statement you obtained from Chandler basically admits to undertaking some of that behaviour, but he didn't see it as having any sort of sexual undertone. He felt that all he was doing was just trying to welcome Monica into the team and make her feel appreciated and welcomed. Does that matter that Chandler had no sort of ulterior motive in respect to his behaviour?
Not really, no. So there's a couple of things wrapped up in that. Certainly what Chandler thought about the conduct is not going to be relevant. It goes back to this idea that workers' compensation merely has to have the connection to employment and is otherwise effectively strict liability. The motivations, it's not a fault-based system in that regard, so the motivations of Chandler aren't going to be relevant. There's also this idea about objectively what happened, and that's a different question. And it might be that objectively what Monica is saying happened isn't what happened, or it might be objectively what Chandler said happened wasn't what happened. That's a factual issue to be sorted out. But the other thing too is that even if the worker got the wrong end of the pineapple, as long as there was a pineapple to get an end of, then it doesn't matter. So it's this idea of perception. So we've got in New South Wales a case of the State Transit Authority of New South Wales and Fritzi Chemler, one of our Supreme Court decisions, and in that decision, Mr. Chemler perceived a number of things that happened in and around the workplace, including graffiti and various other things, as targeting him. These things definitely happened in the course of his employment. They were definitely done by his co-workers. They weren't targeting him, but that was his perception of those events. And as a result, it was accepted on the basis that this is a strict liability scheme, that he had a psychological injury arising out of his employment. So the distinction is, there's another case, I think it's Police and Thompson, where someone has, because of an existing mental illness, perceived things that weren't actually happening. And that's the distinction. So if it wasn't happening and that person has, in that case, thought they were being surveilled or listened to because they saw a truck parked on their street, it had nothing to do with their employment. In that case, it's not held to have that connection to employment because their perception's not based on real events in employment.
Yeah, okay. So in this scenario, I think from that, then liability would probably have to be accepted for this claim, because it would be accepted that Monica's perception of what took place was enough for her to suffer the adjustment disorder with mixed anxiety and depression.
That's right.
Okay. And does it make any difference, Tim, I'll just ask you one final question, whether if Monica and Chandler were in a consensual relationship and then it recently ended badly, and that's what prompted Monica perhaps to lodge the claim for compensation?
I think that sort of loops back to our original discussion.
Yeah.
In response
around
to the first question,
connection.
Lorna. That's right. And it's in relation to, is this something that has employment as the main contributing factor. It might even go to the question of whether it's a personal injury or a disease. There might have been a sudden and identifiable change in Monica's psyche that resulted from the breakup in the relationship. And then it would be a question of whether employment was a substantial contributing factor. So it gets a bit curly, but yes, it does make a difference because of you'd be looking more closely at that connection to employment and the nature of the injury.
Yep. Okay. So I think there's some really good concepts there discussed, Tim, around the importance of understanding what a psychological injury is, making sure we get a good background, the factual matrix of the he said, she said scenario, and determining whether or not it's sort of an injury simpliciter or an injury that's arisen out of a disease, and then working your way backwards from that. And then also trying to develop the factual matrix in and around whether or not an employer or self-insurer can rely on any administrative defences or any defences in the legislation, and also the perception of a worker can be enough in order to satisfy the legislation for a compensable injury.
That's right. I probably should add a bit of a New South Wales coda though, Alana.
Okay, go for it. Absolutely.
That is that earlier this year we had some proposed amendments introduced to our Parliament to the workers' compensation legislation. Now, they're still very much the subject of inquiry and debate, and most recently it looks like there's some opposition to a number of the elements of it.
Okay.
But all of this hard-fought knowledge that we have about our jurisdiction, particularly in relation to psychological injury, might change a bit.
Yes.
Because certainly one of the things that's proposed, and it goes to these questions of causation, is that rather than simply having the connection at work, there needs to be particular types of conduct that have occurred in order to establish that you have a psychological injury. And for instance, this idea of bullying, which is commonly applied in workers' compensation terms to any sort of interaction that might have a bit of friction to it.
Yes.
In the proposed legislation, one of the things they say is, well, no, this has got to align more closely with the Commonwealth or state-based safe work or work health and safety legislation about bullying. So bullying has to have these relevant components. It's got to be repeated. It's got to be unreasonable. So that would apply, for instance, to Simon's case. If the conduct was found objectively to be reasonable, for instance, then he wouldn't get through the door to establish a psychological injury, so we wouldn't even need to look at that defence. And that defence is also to be changed, I think, to align with the other states. It's going to be more about administrative action and to be more expansive in terms of what it covers. I think certainly even under the new legislation, Monica's case, leaving aside that question of what's work-related and what's not work-related, would have a compensable injury.
Okay. Sounds like we might need our own podcast just in relation to these New South Wales changes, Tim. Thank you very much for your time. It's much appreciated, a really good insight into that. And I hope that our listeners have taken a lot away from today's discussion. Just wanted to thank everyone for tuning in, and especially you, Tim, for your time. If you have any questions or want to chat more about anything we've covered off today, please feel free to get in touch. You can find our details at hallandwilcox.com.au or connect with us on LinkedIn. If you like today's episodes, please rate, review or subscribe wherever you get your podcasts. And thanks again, and we'll catch you next time. Bye for now.
Thanks, Alana. Bye.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.